Okay, hi everybody. Welcome to tonight's presentation, An Introduction to Inherited Property and Wills by Louisiana Appleseed. My name is Michelle Shoriak. I am the Director of Conservation and Education here at the Preservation Resource Center. For those unfamiliar, the PRC is a 48-year-old nonprofit organization dedicated to preserving New Orleans' historic architecture, neighborhoods, and cultural identity through collaboration, empowerment, and service to our community. I want to start by thanking our the generosity of our members and donors that enable us to host these free classes and events, and especially want to thank Louisiana Appleseed and our presenter tonight, Jonathan Reynolds, for volunteering his time to come and give this presentation. Jonathan is a staff attorney for Louisiana Appleseed, focusing on heirs property. He earned a Bachelor of Arts degree from UNO and a law degree from Loyola. He began his law career as a title examiner and abstractor for right-of-way and oil and gas projects. And prior to his legal career, while displaced from New Orleans due to Hurricane Katrina, Mr. Reynolds was a research assistant at the Insurance Institute for Highway Safety. He is a native of New Orleans and longtime member of the Bunny Friend Neighborhood Association. So without further ado, I will go ahead and introduce Mr. Jonathan Reynolds.
Hey, good evening, everyone. I'm Jonathan Reynolds, staff attorney for Heirs Property for Louisiana Appleseed. I'm going to give you guys an overview of the issue of heirs property. We're going to get into wills, we're going to get into estate planning, but mostly we're going to focus on heirs property. Who is Louisiana Appleseed? It's actually, we're not just one organization. There are Appleseeds in multiple states. There's also even Appleseed in Mexico. And mostly what we do is we train lawyers, we educate the general public, and we have each one of us picks our own issues that we like to settle on. So the big issues that we're dealing with right now in Louisiana are heirs property and legal civil aid. And that's what we're primarily focusing on right now. I'm going to read all that. What is a will? You guys all have your wills done? No?
Like right here.
Well, a will is a document, and it basically dictates how your property is going to be divided after your demise. There are different types of wills in Louisiana. The two types of wills that are valid in Louisiana are holographic wills and notarial wills. I'll explain that to you. Notarial will is what you generally think of when you think of a will. That's like when you go to a notary, you go to a lawyer, they write it up, and that's your will. And you have two witnesses. So the thing is, in Louisiana, we have very strict will requirements. Like if your will does not follow these strict requirements, it could be considered completely invalid if any one of these things are missing. So it has to be in writing, obviously. It must be dated. And by dated, each page has to be dated. Must be done in the presence of a notary and two competent witnesses. Not one witness, not just a notary and two witnesses. Testator must sign their name on each separate page. So when you do a will, if you go to a lawyer, you go to a notary and you're having your will notarized, you have to sign every page of the will. If one page of the will is not signed with the testator's signature, the will is completely invalid. It's like you never had a will. It's not a common mistake that lawyers, notaries make, but it is something to be aware of to make sure that your will does not fall apart because of that. Also, it must be a notary. Yeah. And then there's a clause at the end. The notaries are normally pretty good about taking care of all this stuff, but these are things that you need to know. So one of the issues that I'm starting to see are people do like the online wills where they download a will from online. Not necessarily in and of itself a problem, but I've seen certain wills like this that are more general and not Louisiana specific. So maybe it'll only have one spot for a witness. If you only have one witness, your will is invalid in the state of Louisiana. Must have two witnesses, must be in front of a notary. Holographic will, this is the fun one. An holographic will is like sort of like, I don't know if you guys are familiar with, ancient Roman times. It's where a person can handwrite a will by themselves. where you completely handwrite a will, you date it, you sign it yourself. This can be a valid will in Louisiana, but the problem with this is obviously it's very much open to challenge. One of the biggest challenges, first off, is it must be authenticated, where it's like, did this person actually write this? So then someone's gonna have to testify this is actually this person's handwriting. This is not a recommended way to do your will, but I think most people in here said that they don't have a will. This would be a good stopgap until you're able to find a lawyer or a notary and have your will done. We have a question?
The full thing has to be handwritten or just?
Full thing handwritten, yeah. Whole thing handwritten. Not just typed up and then you sign at the bottom, no. If you do it like that, it'd have to be a notarial will. The entire thing has to be in the testator's handwriting. Yeah, but I do not recommend this as a stable form of having a will, but it is a thing you can do until you get mad. Like, let's say someone's on their deathbed, someone has like an accident. They need to memorialize their wishes immediately. This is a useful tool for that. This is a useful tool until you can get to the notary, until you can get to the lawyer, or if you're a person who is of lower income and you can't afford a lawyer, until you can find such a situation like this, it is better than nothing. You have a question?
You said that someone would need to,
Authenticate your handwriting?
Can that be a relative?
It's most likely would have to be a relative.
There's no stipulation on who.
There's no specific stipulation that I know of, no. It could be a best friend who you write a lot of letters to, correspond with. It's most likely going to be a judge going through it, and it's going to be very complicated. I don't think I've never been a part of one of these being administrated. So, but I do not imagine that it's anything less than a mess.
And I heard they had to be in blue ink.
I'm sorry. She heard that someone said that they believe that it had to be in blue ink. I don't know. There's no ink color stipulation that I know of. It might be, but not in Louisiana. No. Can I revoke my will? There are different ways to revoke your will. The number one way to revoke your will is you personally physically destroying it. If you are like upset with your relatives, this will is no longer valid and you destroy it, it's revoked if you personally destroy it. That's different from, like, let's say an instance like a Katrina or a house fire where it's destroyed by circumstances. The will is still valid and there are ways to authenticate it. It's a lot of trouble, but it doesn't mean that your will is invalid just because it's been destroyed. It's only invalid, revoked, if you personally yourself destroy it. Yes?
May I ask a question?
Yeah.
So if you have a will and you have it in your lockbox in your house,
Mhm.
the house burns down and the box is burned, but your attorney has a copy of it,
Mhm.
does the copy satisfy?
The copy, I'm not going to say that the copy satisfies. The copy, like, let's say it's a photocopy. Let's say it's a photocopy. If it's a photocopy, it's not the same as the actual will with the actual signatures on it. There are instances where people have duplicate wills where they're each notarized, they're each signed separately. That is a thing, but then that sort of defeats the idea of you being able to revoke it by destroying it. Then it brings up the question of, do you have to destroy both of them to revoke it?
Got it.
And that's like a question that's going to be a little bit beyond the scope of this. But in an instance where it's duplicate wills, where you got each one notarized, you got each one signed, yeah, you could use the one that your lawyer has. If it's a photocopy of the will, it could be used, but then it's going to fall under different sections of the law, and it's going to have to be authenticated separately from your actual will.
Got it.
Yeah, that's due to prevent fraud and things like that. Yeah. Another way that you can revoke your will is you have another document that says my previous wills are all revoked. The way that that normally happens is, you have a will, your life circumstances change, you write a new will. And instead of having to go back and destroy the new will, you just state in the most current will, all other previous wills are revoked. That's the most common way that wills are revoked right there. What if I have no will? Now we're getting into the thick of things right now. This is a situation that many people in Louisiana are in right now. And what happens, that's called, you have if you were to pass in this way, it's called intestate. And when it's intestate, the way that your property is going to devolve is going to be by process of law. You know, if you write a will, you can go, I'd like to give my cousin everything. If you write a will, you can go, I'd like to give my neighbor everything. If you don't have a will, it's going to go down a very specific path, your property ownership. Who are the heirs? Intestate succession order. So this is basically who takes first. So if you die in Louisiana, you don't have a will, your children get everything, right? Let's say you don't have children, or let's say your children are deceased and only your grandchildren are alive. Your grandchildren take in the spot that your children would have taken. That's what that word means, descendants. Let's say you don't have any descendants, you don't have any children, you don't have any grandchildren, never had children. In this case, it's going to be your parents and your siblings who are going to take. Your siblings are going to inherit the actual property. Your parents are going to inherit a usufruct over the property, basically.
For what?
Usufruct. You own the actual title to the property, but the parents will actually have control of it. So in Louisiana, we have different ways of owning property. And when you own property, you can own the actual land where it's like, okay, I'm the person who's responsible for taxes. I'm the person, if you're going to drill an oil well on this, I'm the person to ask. And then there are other instances where this person actually gets to use the property, even though they don't have the naked ownership of it.
Okay.
So the normal way that normally comes up is with married people and community property. If you are married and you own community property with your spouse, one of the spouses pass, the spouse who is still alive, they own their share of the property, but now they have a usufruct over their deceased spouse's half of the property, but the naked ownership is the children. That's a little bit complicated. Sorry about that. Well, I'm gonna have a chart later. Yeah, I'm gonna have a chart later that more explains it. Okay, and then if you don't have any siblings, you don't have any parents, you don't have any descendants, then your surviving spouse can inherit the property outright and their own. You don't have a spouse, that's when you get to these instances where it's like, distant cousins and stuff like that get to inherit the property. What is heirs property? Now we're getting into the thick of it. Heirs property comes about when necessary legal work isn't done after a property owner dies. If you do nothing, the right to live on the property goes into an heir. Heirs are related to the deceased property owner by blood or marriage, are named in a will. The heir legally owns the property. So the normal way that heirs property comes up, maybe an elderly person, they pass, their children inherit the property, they own the property now. There's never a succession, there's never donations into one person. So now if the person had 5 kids, all 5 of these kids own this property jointly, they own it as heirs property. That's the most basic way that it happens. How much heirs property is there in Louisiana? There's a lot. One of the things that actually put heirs property on the radar of most people in this part of the country was Hurricane Katrina. I'm going to get into that a little bit more, the ramifications of Katrina, but that's where most people started to notice it. When folks, I'm going to get into, I think it's probably next. Let's see. Why does heirs property persist? So why do we have people who own the property jointly with their relatives and they never work to get the succession, work to donate their interest into one person? It's expensive. It's complicated. I'm going to get into how complicated it is, but even just speaking with people here today, one of the primary ways to prevent your property going down the rabbit hole of heirs property is to have a will and having a plan of who you're going to donate it to and how you're going to donate it to them. But even in this room, a lot of people, we haven't done our wills yet because it's expensive, it's complicated, it's a difficult thing to even have to think about, right? But then there's also the issue of historic disenfranchisement, distrust of institutions. There are certain demographics that are more likely to own property in an heirs property type situation. Normally, it might be African Americans, Black people, Latinos, Native Americans, different historically disenfranchised groups. Because what happens with this property is your grandparents might have bought a piece of property in 1940, your great-grandparents, great-great-grandparents in 1940. There are reasons why they might have not had a will. There are reasons why the next generation might have not actually gone to the courthouse and notified people that this property was held in a very fragile format of ownership. And that's one of the things with heirs property is a super fragile piece of ownership. We're going to get into it later, but the primary threat of owning heirs property in Louisiana is if you and your remote cousins own a piece of property together, any one of these cousins who decides can force the entire family to sell the property. And so back then, it was a real threat. I'd say it's still a real threat to this day, concern. But then that's how a lot of people accumulated a lot of land by specifically finding pieces of property that were owned in this method, and then finding the one relative who wanted to sell, and then busting the entire property open and forcing it to sheriff sale. We're going to get into that a little bit later. Well, but that's all to say that that's one of the reasons why property people in the 50s, 40s, 30s were hesitant to even notify folks that they own property in this method, because when you go to the courthouse and you're doing the donations and you're trying to consolidate ownership, anybody who's watching the records can see that, and it was an actual strategy that people, I would say even to this day, use to acquire property, buying out a relative and then forcing the entire property to sell.
When you say forcing it to sell, how would they do that?
The question was, what is the process of forcing the family to sell the property? So let's say, so we have this chart up here now. The people in green are the people who are still alive. The people in, like I said, the amber, these are former owners of the property who are now deceased. The original owners were Alex and Martha. Alex and Martha had 2 kids, Belinda and Bessie. Belinda had 2 kids, Jean and Jock. Bessie had 3 kids, Jules, Josephine, Jared. Jean had 3 kids, Sally, Saul, Sophie. Josephine had 2 kids, Tina, Tony. Sophie had 2 kids, Yvonne, Ignatius. The people in green are the current owners of this property. It started off with Alex and Martha, and then when they passed, you can see how it dovetails out. And it started with 2 owners of the property, and now we have 1, 2, 3, 4, 5, 6, 7, 8, 9 different owners. The question that was asked is how are people forced to sell their property? Out of these 1, 2, 3, 4, 5, 6, 7, 8, 9 owners, any one of them can decide, I no longer want to own this property with you. And what could happen there is if I don't want to own the property with you, I can force a partition. We have a slide for this later, but I can talk about it now because it's my favorite thing, partition, because this is the biggest danger of it. And so we're all in the understanding that any one of these people in green can force a partition. Another thing that any one of these people in green can do is sell their interest to a third party. And what happens in an instance like this, if the property is valuable enough, or if somebody wants the property enough, instead of them buying out all 9 people, they buy out 1 person and then they force a partition. In Louisiana, we have 2 types of partition. We have partition by licitation, and we have partition in kind. Partition in kind would be, let's say you own 20 acres in Plaquemines Parish, and you have 5 siblings, you have 4 siblings, and one of your siblings decides to partition the property. If you have 20 acres, you can do a partition in kind. You get 4 acres, you get 4 acres, you get 4 acres, I get 4 acres. That would be a partition in kind. That's the favored method of doing a family partition of property in the state of Louisiana. When I say favorite, that's a on paper favoring, that's a jurisprudential favoring. In reality, that's not what normally happens. Also, there's the idea of if we own a house, we can't split a house 5 ways. That's where in the other type of partition comes in, partition, elicitation. Basically what that is a sheriff sale. It's not technically a sheriff sale, but it's basically, we're gonna put the house up for auction. Everybody splits the proceeds. The reason why that's a very dangerous situation to be in as an heirs property owner is, let's say Sally, Saul, Yvonne, Ignatius, Jock, Jules, Tina, Tony, Jared, all have an interest in the property. Let's say Jared still lives on the property. There's a chance that Sally, Saul, Yvonne, Ignatius have never even seen this property. Just like some of you guys might have in your family a piece of property in a different state than what you grew up in, maybe like a ranch you guys would go to or something like that, or grandmother's old house. But then you also have more remote cousins who've never even been to the property. They have no attachment to the property. They have no fondness, no memory of this property. So when someone calls them on the phone and offers them $4,000 for their interest in the property, they're going to say yes. You know?
Do all of those people have equal shares, or does
Not-
it kind of get divided as it kind of goes down?
It gets divided. Do all of these people have equal shares? No, all of these people do not have equal shares. I don't know if you can see it from here. I did the math for this one. With this one, okay, I did it before. Yeah. Sally and Saul have 8.33% each. Yvonne and Ignatius have half of 8.33% each. Jock has 25%, Jules 16%. I hope these numbers add up. Tina has 8.25%. Tony has 8.25%. Jared has 16.5%. Any one of them, regardless of how small their percentage is, can force this partition. I've seen instances where it's hundreds of people, and there might be two people who have like a 30% interest, a 30% interest, and then the other 40% interest is just all over the place. And a person with 1% interest can also force a partition just as well as a person with 30% interest.
I'm sorry, I have another question, but I have a piece of property in Lafourche Parish that's exactly like this.
Mhm.
And a guy from outside our family did exactly this a year ago. And now he owns like, I don't know, I think it was like 60%, so it used to be 100% our
Wait,
family.
so you have a property in Lafourche Parish and it's owned by multiple people, and an outside person, someone not related to the family, a third party person, came in and bought a certain percentage of the property.
But he bought it from someone that wasn't family because somehow somebody previously
Yeah.
bought a percentage. There's all percentage.
Yeah,
The title is like based in percentages.
yeah, and that's what it is. Maybe it must be a large piece of land. Can you appeal the person buying the property? He doesn't have to be in the family to buy out a family member. I'm not saying, I'd have to look at it, but I'm not saying there's no way to appeal it, but there's nothing improper about a family member selling their interest. And what happens with, like, maybe this is a piece of property that you have in Lafourche Parish. There's a third party person who owns interest in the property, and apparently they bought their interest from a different third party person. Then the question would be, how did that third party person get their interest into the property from the family? Sometimes these things can go back 100 years. It depends on how long the property has been in your family to trace where the interest came out. It may be, it might be, it might not be, but that's what, you know, in my previous life, I would have been the guy who would get hired to go in there and go, okay, here's where this person got their interest from. I'm gonna get into a little bit later. One of the best places to start to find out this kind of information, if you have the time or wherewithal, to go to the assessor's office in Lafourche Parish. Do we have any more questions on this one, this slide, family tree? Okay. One of the things that you can do to, like, oh, this is like an example of, so what we were looking at before was for heirs property's sake, this is a very simple family tree. It's definitely still difficult to clean up, but it's not impossible to clean up. But this happened after 1, 2, 3, 4, 5 generations. We already have 9 different people owning interest in the property. Imagine after this generation, we add an additional layer, it's going to go up exponentially. So every generation that goes by without this getting cleaned up, it's going to get exponentially worse. I think someone in the, I don't want to ignore the people in the chat. Somebody in the chat has a question.
Open the chat right there, and then there's also the Q&A box. The one says, we have a will, but it is not applicable to the succession of a house. How do we go about handling that?
Yeah, a will, I'd have to, someone would have to actually look at the will. Here's the thing. A person might own lots of property. Some wills are 100, like, what's his name? The guy who owned, John Audubon, who owned Audubon Park. His will is hundreds of pages long. It's hundreds of pages long. Some other people's wills are 1 page long or 2 pages long. And you could own a lot of property and have a long will, or you can own a lot of property and have a very short will. Your will doesn't necessarily have to say, this goes to this person, this goes to that person, this goes to that person. Your will could say, everything goes to this person. Or it can go, all of my land in this parish goes to this person, all of my land in this parish goes to that person. It could be, and it might, even though it might be a person who has a lot of land, it could still be a very short will. So that the house is not necessarily mentioned in the will doesn't mean that the house is not covered by the will. But that's something where somebody would have to actually look at the will. But normally it'll say all of my tangible property in the parish of goes to this person or goes to this group of people. Or if it's a house, the person goes, everything I own goes to this person. And everything I own means everything I own, even if they don't specifically say the house. Someone has a question. The question is, what can I talk about the difference between usufruct versus trust? Usufruct and trust are not necessarily in conflict with each other. There are things that can exist at the same time. A usufruct is when you own, the way that we explained in Louisiana, it's like there's a naked ownership of the property. That's the person who actually owns the land. But owning the land is not necessarily the same as owning the use of the land. So a good example of that would be like this is not a usufruct. I'm not saying that this is usufruct, but I'm trying to make an analogy for you guys. If I rent something to you, I still own it, right? But you have the use of it. Usufruct is a little bit more durable than a renter situation. A usufruct would be, I own the land, but you own the right to use the land. And the normal way that a usufruct comes about, married couples who own property as community property, one person passes, the spouse who passes, their naked ownership of their half of the property goes to their children. But the usufruct is still with the spouse. And the reason why that's there is so, let's say me and someone else, we're married, we buy a house together, one of us dies. That's so that our children can't push me out of the house. So I have control of the house, even though they have the ownership of it. So like I can't sell the house without them getting half. They can't force me out of the house. They can't force themselves back into the house because I have full use of the house, despite only owning half the house. A trust is a different situation. A trust is a form of ownership. It's sort of like, if everyone in this room, we get together, we go, we're going to buy this thing in trust. We're going to have a trust. And the trust would be, the trust owns the property, but we own the fruits of the property. So like if we rent it, whatever comes from us renting it, or if we sell it for a thing, we get the actual income from it, but the trust actually owns the physical property. So I guess they are a little bit similar. This is a very common question that Talver Burnett has asked. What if Jared is living in the property and is listed on usufruct created by the family member that lived in it before they passed? Yeah, so the usufruct, it depends on how complete the usufruct is. I guess what's happening here is there's a parent, they pass and they leave a full usufruct to one of their children, let's say Jared, but naked ownership is still the same way that it was before. That is a great question, but in the state of Louisiana, you can't force someone to hold the property in division with you. And there's a special circumstance for community property married usufruct that doesn't exist in this situation where you achieve a usufruct through a will. The family members can still, to my knowledge, still force a sell. Yeah, so that's not a 100% way to protect it. I'd have to look that up, but I'm pretty sure they can still force a sell in that situation. Okay, so that was a simple heirs property family tree situation where it's only 9 people. But then, you know, we have instances like, this is just to show you how complicated it could actually get. This is Queen Elizabeth and her descendants. We got, who do we got? We got Prince Charles, we got Princess Anne, Prince Andrew, Prince Edward. I don't even know who Prince Edward is. We have Prince Charles' children, Prince William, Prince Harry. We have their children's children, Prince George, Princess Charlotte, Prince Louis, Prince Archie. I think there's one more in there too. So you can see how quickly these things dovetail out. And so like Queen Elizabeth just recently passed, and these are all these people under a certain line are all the people who stand to have inherited something from her. These are all of her heirs. Some of these people still alive, some of them have passed, and it's a lot of people. And normally in a situation of heirs property, it's normally, you know, in that amount of time, it can get even bigger than that. She's been around since okay. Title clearance of heirs property. So the reason why I like to tell people about this is to sort of, even though this slide is a mess, to demystify the process. A lot of people have questions about, maybe you have a question about your property in the FOOSH, someone else might have a question. The first place to get information about your property is from the tax assessor's office. You don't have to physically go to the tax assessor's office in 2022. Back in the day, we used to have to actually drive out to these parishes. What you can do now is you can go to their website. If you know your property parcel number, that's the main thing you're going to want to know. If you know the parcel number, you can put that in and it'll bring up your property. It's going to have specific bits of information on the property. The most important thing that we're looking at from an heirs property standpoint is who does the assessor say owns the property. So in an instance where it's heirs property, I might have inherited a piece of property from my grandmother. The assessor is still going to have her name on the property. It's not going to have my name. It's not going to have my cousin's names on it or anything like that. That's a true heirs property type situation. And the only way to rectify that is to have a succession or different things like that. Another thing that's going to be on your property tax card with the assessor is going to be a property description. They're a little bit hard for people who don't look at them all the time to decipher, but that's going to be on there. Another thing that's going to be on your tax assessor thing is who does the tax bill go to? So this is another tip off because sometimes you'll have an instance where it'll say this person who bought the property in 1950 is the owner, but we're sending the tax bill to this person. And that's normally also a tip off that you're dealing with a piece of heirs property. The next place you'd want to go besides after the assessor's office is the county or parish clerk of court property division. That's where they're going to have the actual property records. In some parishes, depending on how far back you want to go, you might have to deal with physical books. Even in Orleans Parish, if you go back, I think more than 20, 30 years, you're dealing with physical books now. You're no longer on the computer. But for more recent modern transfers, you can put in, with these, you're not going to be doing it by parcel number anymore. You're going to be doing it by the actual person whose name the assessor says owns the property. So you go to the assessor's office, you figure out the parcel number through the address. Who does the assessor say owns the property? And then in the clerk of court property division, you're going to want to, they call it running that name. You're going to want to research that person's name. And then that's when you can start to build a family tree. You can start to build a chain of title and see everyone who's owned the property before. The way the normal strategy is, you find that person's name and the deed where they got the property, And that's normally going to be annotated on the assessor's website on the tax card. And it takes a while to actually be able to decipher these things, but maybe someone in the office will go, oh, that's book 12, page 97. That's what that means. And then when you find that person's deed, it's going to say who sold it to them. And then you can find that person's deed. And you can go all the way back to the day that the property was patented from the state of Louisiana or the US government. And it also helps you build a family tree in an heirs property type situation. Another way to do it, to get additional information on the heirs property, who owns your property, is through non-traditional, non-legal means, online census records. If you live in Orleans Parish, you get free access to online census records through the public library here, through the internet even. You can look through the courthouse for affidavits of heirship. Those are normally pretty good. They spell out everything. But then also another thing is lawsuits sometimes. Maybe people got divorced, and in the divorce, it spells out who these folks' kids are, things like that. Other methods to find other people who might have an ownership interest in the property with you, archival newspapers. If you live in Orleans Parish, you have free access to the Times-Picayune going back to the 1800s, where literally the search engine is powerful enough where you can put in your address and it'll show every time your address came up in the Times-Picayune. And up until recently, a lot of sales were cataloged, liens were cataloged in the classified section and things like that. So you can actually find out a lot of information on a piece of property just from the archival newspapers. In the public library, if you're in Orleans Parish, we also have a phone book history, where it's like every phone book for Orleans Parish going back to like maybe 1910. So you can figure out who lived in that house beforehand through the old phone books. That's a very arduous search. I don't recommend it. Another great resource is findagrave.com. I don't know if you guys are familiar with that. There are a few other websites similar to it, but I like findagrave.com to start with, where you could, let's say you have a relative, you can search them on findagrave.com, and sometimes it'll return their obituary and even a picture of their actual tombstone. And you can gather information from the picture of the tombstone, because some tombstones will say daughter of, son of, and then that's another way to help you build out your family tree. I think this came up a few times. This is normally the question that people always want to ask, and it's related to a question we had earlier. The idea of if you have a relative who lives on the property, or you might be the relative who lives on the property. You might be the relative who lives on the property and you pay all the taxes and you take care of the entire property. Your cousins, your siblings, they don't have anything to do with the property. Does that mean that you own the property by yourself? It does not. You taking care of the property, when in the state of Louisiana, if you have co-owners, anything you do to benefit the property is assumed to be on behalf of all of your other co-owners. So that's a question that's commonly asked, where it's like, well, they don't do anything with the property. They make me maintain it. It's like, well, so how can they force me off of it? How can they force a sale? This should be my property. And I do get the impetus for that, but that's not really the way that the law works. The major protection that a person who owns property in this situation, where they actually reside on the property and their relatives want to force them off, their biggest protection is they can keep a catalog of all the money that they've spent in repairing the property, all the money that they spent on taxes for the property. And if this were to be forced to a sale by one of their relatives, they would be owed an accounting of that money back, or at least their percentage of that money back. So that's the major protection. There are ways to, the term in Louisiana, some people might call it squatters' rights. We call it adverse possession. There are ways to have adverse possession against co-owners, against relatives, but it's very difficult and not to be relied upon. You have to physically, actively bar them from the property. It's messy. I've probably only seen that work twice. How are we on time?
6:40.
Oh, plenty of time. Okay. Oh, am I boring you guys? All right. All right. Yeah, because I don't. Yeah, just making sure I got the. Okay.
And like a small claims lien, that would be at the property assessor's office that we.
Yeah. No. The small claims lien, the property is, the tax assessor may or may not have something like a lien noted. You want to go to the actual parish property records. So in Orleans, it's right by the Superdome. But it's an actual, you want to go to the actual place where the property records are stored. That's separate from the tax assessor's office. The tax assessor's office is down here, the property records are down here. You want to go where the mortgages are stored. Yeah. And you can look up on the computer there, you can actually put in the address and it'll show you everything that's related to that address from 1981 forward, I believe, in Orleans. But it's sometime in the 80s up until the present. So if it's a lien that's in like the last 20 years, you probably would be able to find it through the computer at the property records office. What is the issue with owning heirs property in this matter? So we covered a lot of it. It's a very unstable form of property ownership. You run a lot of risk on actually losing the property, even if most of the people in the family want to keep it that way. There's the long shot that admittedly almost never happens, where one relative physically evicts the other relatives from the property and gets it through acquisitive prescription. It's near impossible. I've only seen it once. It's near impossible. But then there's also the issue of sheriff sales and tax sales. What happens is in these instances, when everybody owns the property, then it becomes a question of who should be paying the taxes. And once it becomes a question of who should be paying the taxes, it ends up with no one paying the taxes. Not to mention the issue of that I brought up with you guys earlier, just you paying the taxes does not give you a greater claim to the property. So when you own property like this, people are actually disincentivized to be the person who steps up and pays the taxes. So a lot of times that's how this sort of property leaves the family, is through tax sale. But then there's the other issue we spoke about a little bit earlier, the idea of forced partition. You have a relative who no longer wants to own property in this method, and maybe they're not willing to accept a buyout. They're like, oh no, I don't want you guys to buy me out. I want to force it to partition. And that's actually a thing that happens in these situations. There's a lot of tension sometimes, especially in a more urban environment where it's just a house rather than, 40 acres or 50 acres. When it's just a house, there's a lot of emotions, a lot of tension that comes up with who gets the house, who got what. You get to hear people having arguments about, well, she paid for you to go to college. And I'm like, that was 50 years ago. What are we talking about? But it comes up and there's a lot of arguments. And this is one of the reasons why I like to focus on people clearing up the problem before it starts. Because once your relatives have to deal with it, they're going to be dealing with a lot. When we pass, our relatives, our descendants are going to be dealing with a lot. And it's going to be hard for them to deal with this. So I try to encourage people to have this one thing taken care of so that they don't have to worry about it. We talked about this stuff earlier, the idea of partition in kind versus partition by licitation. And I don't know if I specifically mentioned this last bullet point about a cottage industry of land speculators who buy interest through relatives and force partitions. That's an actual business model that some people have, depending on, it's especially in more rural parishes, but I believe it's also starting to get to the urban parishes with I'm just saying if I want to say the word, with the advent of the Airbnb, the idea that this piece of property that was probably only worth, $200,000, $300,000, which is a lot of money, which might have been worth $200,000 in 2016, the idea that it could be used as an Airbnb now. Okay, you ever see the signs where it's like, we buy houses? You ever get like a piece of mail where it's like, we'll buy your house? It's a business strategy that a lot of folks have. And one of the things that they do, the more savvy ones, is they specifically target pieces of property that are owned in the heirs property type situation, because they're aware that they don't have to buy out the entire family. They can buy out one person force it to a partition cell, and just show up with way more money than the family is going to have. So in reality, okay, someone's raising their hand. Let's see this.
So if you go to Q&A, I think.
Oh,
she's got a
Q&A.
Question in the Q&A. So I put Janice at the top.
Does Louisiana Appleseed provide pro bono help to individuals with these issues? There are certain cases that do come to me where I end up handling them. We work with Southeast Louisiana Legal Services, specifically for heirs properties issues, more specifically for people who might need a will. If you're a low income or you're elderly and you need a will, Southeast Louisiana Legal Services has received this incredible grant from the AARP to actually provide people with wills for free. If you're in a situation where you need a succession, or maybe a succession could clear up your heirs property issue, and you happen to be low income or elderly, or someone else who's on the property is low income or elderly, yes, Southeast Louisiana Legal Services, through a partnership with us, sometimes the actual issue might get complicated enough where it does end up on my desk, where I am the person who does some of the background title research and things like that. But it would be Southeast Louisiana Legal Services. Hold on, I don't want to step out of the frame. I'm going to give you guys a number for the hotline for this. This is Liz Dunbacher. I'm going to give you guys a number for this that you can call, where it'll be Southeast Louisiana Legal Services, Maureen there. And if it's something she can help you with, she'll let you know. But yeah, partition, that's one of the dangers of owning heirs property, is that it's always a chance you'll lose it with, through no fault of your own.
There was one other question in the.
Okay.
And this is what he was just talking about with the phone numbers on the back, so I'll go ahead and put those numbers.
We have a will that specifies everything goes to me and my adult son. Orleans Parish says the will is not valid to put the property in my name after my husband of 33 years passed. One of the things that I don't know the exact reason why this will is invalid. I haven't seen this will, but I will say that the will formalities in Louisiana in general are very strict. It's not very difficult to write a good will in Louisiana, but if you make a mistake in any of those things, let me see if I can go back up. So a will in Louisiana must be in writing, must be dated, in the presence of a notary, 2 competent witnesses. Testator must sign on each page and must be in front of a notary. If you only have 1 witness, the entire will in Louisiana is invalid. It's like you never had a will. Okay, 1 second. If the person doesn't sign, if the testator doesn't sign every page, no will, entire will is invalid. It's like you never had a will. Didn't use a notary, no will. Other states have different sorts of leniencies for these things, but in Louisiana, if you're missing one of these categories, the will is automatically null and void. Any question?
So is it a full signature on each page, or can it be just
A signature in Louisiana is a mark. It could be your initials. I would recommend that you do a full signature though. Yeah.
Can't the same kind of problems as heirs property happen when people say they don't want to cause a rift between the children and they just leave everything?
Absolutely.
So can you still then partition? Is it the same thing as heirs if they don't make that decision?
So the question is, can heirs property result even if the person has a will? Absolutely. Happens all the time. Some people, their actual will is pretty much just verifying that it's going to go the way that it would go if it were intestate. I get questions sometimes is why would you write a will like that that goes, my children get my property? And then you specifically list your children's names. The reason why you would do that is sometimes people have children that they're not aware of. Yeah. So it's just a common question that people ask, like, why would you ever do that? Sometimes people have children that they're not aware of and that they don't want to to inherit from them. I don't know. So we have an Amanda Fallis here, and she's saying, thank you for shouting out to the library. They have city directories, pre-1926 court successions, genealogy research. Yes, the obituaries through the library's website are also great. Yeah, so definitely if you're doing any sort of genealogy or anything like that, the library is one of the #1 best places to go. I love the phone book, the old phone books. Where was I? We talked about this. Tax sales, nobody pays the taxes, you could lose it. Challenges of heirs property. So even if you and your family have decided that, we don't have these issues where someone's going to sell the property outside the family. We don't have these issues where we need to worry about who's going to pay the taxes. Maybe that's the case with your family. There are some actual arguments, I'm not going to make them today, where it is useful to own property in this method. There are different strategies where people have done it on purpose. But where are the things you can't get around if you own property in this method? So after Katrina, over 20,000 people could not access recovery funds from FEMA because they could not prove they owned their homes, even though they had lived on the property for generations and paid taxes. You ever notice, like, in certain neighborhoods in New Orleans, it's like, why this neighborhood never come back? And what happens is if you actually look at the method of ownership that a lot of these homes were, it might have been a person who bought the house in the 50s or the 60s. And now the person who currently owns it inherited it in the 80s or the 90s, never got the heirs property part cleared up. They had been paying taxes on the house. They had been paying insurance on the house, taking care of the house, really just being a good homeowner. Katrina happens. Everyone else is going back to rebuild. They file for their FEMA funds. FEMA's like, you don't own this house. Is this fraud? Who are you? This has this person's name on it. We're not going to pay you. We're not going to pay this out. Insurance company goes, who are you? You're not the person who owns this house. You're not the name that's been on this insurance policy for the last 50 years. Who are you? Sometimes people might have even gotten an insurance check. Insurance company goes, okay, we'll write the check out to grandma. We'll write the check out to her. You go to the bank's like, you can't cash this check. You're not grandma. And so every barrier that was put in front of people, to repair their homes, if you have one neighborhood where a lot of people own their property like this for whatever reason, and everyone in this neighborhood is systematically coming up against these same barriers, they're going to be less likely to be able to rebuild their homes. And let's say you're the person who lives next to 2 houses like this. You're going to be less likely to fix your house, even if you do have the wherewithal to do it, because it's going to be like, oh, I'm going to be like on my current block, we have probably 4 houses on my current block. Used to be 40. Yeah. Bunny Friend. Yeah. It's Bunny Friend, 9th Ward. I guess they'd call it Upper St. Claude now. I don't know. I don't know. I'm in Bywater. I live 3 blocks away from the Bywater post office. So I'm in Bywater, but you ever hear the question, like, you ever wonder why the Bywater post office is not in Bywater? Because it is. Yeah, so Bywater doesn't just stop at St. Claude. The post office knows the neighborhood names. What's that?
What does happen with all those properties? Do they just stay there?
Some of them the city owns now. Some of them are just sitting there.
So don't you think the heirs property also kind of, well, not only like that leads to blight, but even if you say you have all these heirs to it. And then nobody can really decide what to do to it, because, I mean, I guess they don't want to come and force a sale, but, you know, and it just sits there and it's not kept up, it's not anything, but yet nobody wants to sell it or do anything with it, so it just sits there. And until it rots and falls in.
So the point that's being made is about how heirs property can lead to blight. It can lead to abandonment. It could lead to properties being in disrepair. The idea of when it's this many people who own the property, they're not all going to agree on everything. You might not be able to get 100% agreement on anything. And all it takes is one person to go, no, we're not doing that, and just throws the whole thing off kilter. So yeah, that's like, so not only do individuals have challenges owning heirs property, the actual community at large has issues owning with the ownership of heirs property. And one of the big things is the idea of neighborhood blight. You have a question?
So maybe I'm wrong, but it was my understanding that it, like, let's say you had the 9 owners like you had in the chart. One of the ones that is the current owner, like, let's say it's a piece of land, it's not a building. It's
Yeah.
just a piece of land. One of them could decide, I wanna get a forestry company in and chop down all the trees. Now granted, they gotta hold a certain amount in an escrow for all the owners, kind of thing. But they could just, well, it only takes one owner, one of the 9 owners to decide what to do with it.
So the question is if we have like a rural piece of property, let's say it's 30 acres in Beauregard Parish, a lot of foresting going on in Beauregard Parish, 9 people own the property together. Could one person sell the timber to a timber company? I'd say no. You could sell your ownership interest. You could sell your interest in the property to a timber owner. You couldn't sell the timber.
Who owns the timber now?
You guys all own the timber together. You guys would all have to agree. You guys would have to agree on that. You'd have to agree on that. Yeah. You could sell your interest in the timber. You could sell your interest on the timber. So you have an instance where somebody sold like a marginal interest in the timber company. Well, I'm not going to say that no one's ever stole timber.
The percentage
Mhm.
of the property that I mentioned in LaRouche, he's a surveyor.
Mhm.
So he knew, like you said, he's one of these people that's like making a living out of, you know, he's double dipping, being a surveyor at the same time of doing that. But
I think what you're having is it's a fringe case, and the basic way of explaining it is if all of us in this room own a piece of property together, it depends on what the purpose of that piece of property was, what we can do to it. So let's say let's say we all own a house together. Any one of us could live in that house if we own a house together. You can't turn it into a bar though, because that's not what it was meant for. But let's say we all own a piece of property in Beauregard Parish that had been regularly tree farmed. One of the co-owners could sell the trees if it were a tree farm.
yeah, I mean, this is.
If it were a tree farm but he would also owe percentages to everyone else. But if it's a tree farm, when he buys interest in it, it's still a tree farm once the third party gets their interest in it. And they can continue it to be a tree farm.
Okay, so last question.
So I'm assuming that's the situation you guys run in. Yeah.
If I want to donate my percentage and give into as a conservation easement, would it then completely keep forestry from happening on this?
I have no idea.
Because people are interested in piece of property being a contiguous remaining with trees than getting any kind of little revenue from, I'd rather, that's my problem with this, is that this guy is gonna come along and probably wanna chop the trees down, and I just wanted to stay with the trees. And so if I give my percentage as a conservation easement, it doesn't keep it from happening?
I don't know.
Mm,
Well, I would also say it's like that would be, we're in the realm of legal advice right now. I can't give you legal advice right here, right now.
Can decide to chop it down, that's kind of the opposite.
Well, 1% depending on I was giving you I don't know the actual method. I don't know what the property was being used for before they bought their interest in it. But I was saying that there are circumstances where that would be a thing. It depends on what the property was habitually used for in the past. So, and the thing is with timber farming, not a big deal in New Orleans, but with timber farming, you don't cut the trees down every year. You know, like your grandparents might have cut them down 40 years ago, and it's like, oh, now we got a timber farm. And so even though it hasn't happened recently, you can't farm a timber farm every year. You have to wait a few decades to do it again. Or maybe this is a little bit beyond the scope of what we're doing. But just to say, when you own property like this, your relatives can do a lot of things that you don't want them to do. And then they can also stop you from doing some things that you do want to do. Another community problem that happens when there's a lot of heirs property in the community is this is property that's out of commerce. You know, this is property that even if somebody wants to sell it, it's difficult to sell the whole thing because like not many people actually want to own a percent of property and then force a partition sale. Most people just want to buy the property, fix it up, be done with it. And so what that leads to is blight, abandonment, disrepair, decrease in property value. And as far as the city and municipality is concerned, decreasing tax base. I was just thinking, where am I at on time?
It is 7:06.
25 minutes.
25 minutes. So you guys want the full money? Okay.
Can I ask a question?
Absolutely.
Are there any, and you might get to this later,
No.
or if you do, but if I have a will and everything goes to my daughter, and when I pass, she's a minor, is there anything special, like I should name someone as being in charge of her, or, you know, would it go into a trust, or is there an answer for that?
There is an answer for it. I wasn't prepared for that today, but yeah, there is, you know, what is it, a tutorship? You would name a tutor, not like come on, stop that. It's a legal term. It would be I think it'd be a tutorship, but I'm not sure, but they're very similar things.
In historic documents, they call it a tutor.
Yeah. So you would name a tutor, and then that would be like her guardian. And then you could also give this person ability to do specific things with the property, with whatever you leave behind. So yeah, you would need to do that.
And they would receive a fee for that, right? Like an executor of a will.
I believe so, but I'm actually not sure. I can't answer that. There is an answer to the question. I just don't have it. I've never done a tutorship. Yeah. Or was it? So why would you want to get a succession? Why would you want to get the title cleared up? Why would you want your name or even the names of you and all your relatives on the property? One is, like we talked about earlier, is being able to receive funds after a natural disaster. FEMA's loosened their restrictions greatly since Ida. They've loosened their restrictions greatly, but there's still the issue of SBA loans. I've even encountered certain nonprofits that do repairs to homes that are unwilling to do the repair until you have clear title.
That's why we're doing this, because there's a bunch of nonprofits we run into with.
Oh, okay.
issues,
So,
yeah.
yeah. There you go. So I'm not making it up now. Helps people apply for funds to elevate homes, make home repairs, dealing with banks. Banks they're starting to change, but for the most part, if you own property in this method, the bank's not going to loan money to you. And this goes back into the idea of buying out your relatives and preventing third parties from forcing a partition sale. Let's say you own this house and the house is worth, $400,000. You and your cousins own this house. If you could take out a loan on it, somebody forces it to whatever, you could get that buyout before you could buy it out. You could buy your cousin out through the loan, but you're not eligible to get a loan to use to buy your cousin out. So it's a sort of banks are starting to work on this issue of I'm starting to see they're figuring out some stuff to do for people in this instance, but definitely very difficult to deal with a bank when you're in this situation. Property taxes. Your property taxes could even be more. You own property like this, it's gonna be hard to get a homestead exemption. It's gonna be hard. Most people who own property like this, there are fringe cases where people get homestead exemptions, but for the most part, you're not gonna be able to get a homestead exemption. It does happen though sometimes in very specific situations. And then even then, it's not a homestead exemption on the entire property's taxes, just that one person's taxes on the property, not the other relatives. Like I was saying, FEMA has greatly reduced the amount of information, the amount of proof you need to actually receive FEMA funds after a natural disaster. Basically, all they need now is some sort of link of your name to the property. And that might be a deed or a title to your parents, and then proof that this person was your parent. Yeah. So there's an affidavit you sign. It's much easier now. I'm listening.
Earlier you had when you were talking about this, there was a blue line that said, is that some kind of state rule that's now being?
Which one?
From the bottom of the page, right there.
Oh, so I'm sorry. So when I do these, I do most of these presentations I do for like lawyers and judges. This is the actual revised statute. Yeah.
It's what?
The revised statute number.
Oh, I see.
So sometimes when I take slides out when I do stuff for you guys, but like some of the slides just for whatever reason still have the revised statute number in there.
So they're trying to revise.
No. That's just what they're called. It's already been revised.
Oh, I see.
Yeah.
Oh,
There's a book called the Revised Statutes, and it's just like, it's like yeah. So that's what that is. And it's just a link. It's like sometimes people download the PowerPoint. So instead of me having to type out the entire revised statute, they click the link and it takes them to it. That's why it's blue, because if I clicked it, it would actually open the page. Yeah. But that's mostly for the lawyers and judges and stuff. We also have the idea of now you don't have to go through a full succession. One of the biggest barriers are successions are expensive. Like successions could be like, over $1,000. And that's like, just the paperwork, not even including the lawyers sometimes. So now there's a thing called, small successions. I guess it was 2009. I'm glad I wrote it down. 2009, we have that now. And it's only available to properties that cost under a certain amount of money. It's a very relatively small amount of money in most cases, $125,000. So, in modern New Orleans, modern Louisiana, many houses cost much more than $125,000. But there's also this other stipulation where you can defeat this is when the property owner died over 20 years ago. So this is like a chronic heirs property where grandma died 20, 25 years ago. Now I own it. Now me and my cousins own it. Maybe one of my cousins lives on a property. We need to get this title cleared up. We need to do something, get something on paper, but we can't afford to do a full-blown succession. We're going to do a small succession. And we're able to do that being that it's a chronic piece of heirs property that needs immediate attention before it gets completely out of hand. So sometimes people say that they can't afford a succession. Successions are very expensive, but there are new avenues that have been opened up in the last 10 to 15 years that are less expensive. And experienced lawyers like Maureen at Southeast Louisiana Legal Services, she can clean these things up for people relatively quickly. Solutions. Having a will. But as we mentioned earlier, not just any will, your will can also cause these issues. Another thing that you could do that some people do in their wills, because I believe, this is a personal opinion right here. I personally believe that there are valid reasons for families to own property as a family rather than as individuals. And we have this push where we push people towards, you got to pick somebody, you got to pick somebody. And that is the easiest way to do it. That is the most surefire way to do it. But certain pieces of property are only enjoyed as a family. Like you have a ranch, you got like something with a pond on it. It's like, well, there's a reason why we own this as a family. What are the options to protect your property when it's owned like that? The most common way to do it is put it in a trust or an LLC. For now, we're owning it like we're a business. So now instead of John Reynolds and Eric Reynolds and Kimberly Reynolds all owning the property, Reynolds Incorporated owns the property, Reynolds LLC owns the property, and the beneficiaries are the descendants of Janice Reynolds. So that's the starting to be the thing that's happening for folks. We have a question in the back.
Does putting it in an LLC or a trust get around the problems of passing it through a will?
You can do some of these things through a will, but if you do properly so the question was, does putting it in an LLC or a trust get around the problems of having it in a will or not having it in a will? I assume which specific problem are you talking about?
Where there are some cases where even though you put it in a will that there are problems, I don't know what those problems are.
Well,
Like a for sale.
yeah. Well, yeah, a properly formatted trust or LLC is going to shut that down cold. It's going to shut that. The idea of if your will is not properly formatted, if your will leaves it to multiple people or you die without a will and now you have multiple heirs, does a trust or LLC frustrate that? And I would say yes, if properly formatted, it completely defeats that, because now none of us are owning the property as individuals. We're only owning interest in the proceeds from the property. The actual trust owns the property now. It's sort of like, like Steve Jobs, he owns Apple, and then Apple owns all this other stuff. So it's like a buffer between bad things happening. Like no one person can sell the property because the trust owns the property. They can only sell their interest in the trust. And so what a trust does, if it's properly formatted, or a maintenance agreement, would be something where it's like, oh, we can go to this property, we can go there, we can fish, we can spend weekends there, we can, do whatever. And here's how it's going to be maintained. Here's how much everybody's going to have to pay towards it being maintained, so on and so forth. Still in the family. I guess the most famous instance of this being done with heirs property, I'm going to say famous as a person. You guys ever heard of Ralph Sampson, the basketball player? Nobody. He was like a #1 pick in like 79. What, you heard of him?
No, I had another question.
I heard of it.
Oh, Ralph. Okay, Ralph. I was saying like the most famous example of a family owning property in trust like this is Ralph Sampson's family. I guess he's not as famous as a basketball player as I thought he was. But like his family had, I believe it was in Virginia, they had like a huge public feud over half the family wanted to sell the property, the other half wanted to keep the property, and the half that wanted to keep the property was like, well, we'll buy you guys out. We'll buy you guys out. But there was so much discord between the different sides of the family, so much distrust and discord, that it took them years to even negotiate this buyout. And then once they did the buyout, they put the whole thing in trust. And so now instead of any individual owning it, the trust owns it. And it's like the heirs of these three people all have rights to this property. I believe some of it's farmland, so like people get a percentage of the farm proceeds. Some of it's like recreational camp land, hunting land, and it's like, oh, you call us up and we got like a person who schedules it and you come through and you use it. Not necessarily what's going to happen in an urban environment, but yeah.
If you put a house in trust,
Mm-hmm.
let's say, I'll take my example. I am a mother of one
Mm-hmm.
who's not an adolescent. I wish she was, but in any case, she's not. And I had this house, and I don't really want to sell it to her now.
Yeah.
I don't want to say, you buy it and I'll live in a part of it, because she could disagree with what I would want to do, or I disagree with it. So if I put my house in a trust, what does it do for me? Who's listing her as part of the trust?
What does it do for you specifically personally? How does it change your circumstances? I'm not sure. I haven't written a lot of trust, and I've definitely not dealt with normally the reason why people ask this question is some sort of tax implications question. And I'm terrible at my own taxes.
I might not find it. In any event, I know, I was just trying to keep.
You could give it to, could she not give it to her but give herself usury
Use of
of the
fraud.
property?
Yeah, that's I own one of my uncle's property like that, where he wanted to make sure it went a certain direction, and he donated the naked ownership to me, and he kept a usufruct over it. But when it comes to the tax implications of all these different things, I'm sorry, I don't really know, but that is one way to do it. A trust also, you could do it also through trust, where she owns it after the fact, but she just owns her interest in a trust. But the more simple way would be through the usufruct.
But as part of that, if she was part of the trust, could she go and sell the house?
If it's properly written where she can't, no, she could sell her interest in the trust.
To somebody else?
Yeah, but that's not the house. It just,
Why I'm alive.
well, you'd be also be one of the beneficiaries of the trust. You could write, it could be written where she could not do that in the trust. But one of the things, this is a little bit off topic. This is one thing that you see, like, so if you did it in a trust, or if you did it in an instance where you withheld the usufruct over it, you could prevent her from selling the house. One of the issues that I've encountered before is people will just donate the property to their child. And it's like, if you just full blanket donate it to them, the entire thing, you can't really control what they do with it. And then another thing that I see people do is, like, let's say they're trying to keep the property in the family. They'll have extra stipulations. You can only sell to this person, this person, this person. You can't really do that in Louisiana. It's invalid. Yeah. 10 minutes. Let's see if there's any.
What type of lawyer do you go to discuss this type of stuff?
Oh, that'd definitely be estate planning for you. Yeah.
Estate plan?
Yeah.
I knew that. But anyway.
Well, it's not that simple, because I had a few questions before the seminar tonight, where it was like a estate planning person might not be able to answer that for you. Sometimes it's like, oh, you actually need a real estate person.
Right,
Yeah.
right. Here's the
Yeah.
timeline.
So if you form the trust with 3 people in your family, husband, father, mother, daughter, and they're all equal owners of the trust, right?
Yeah.
And one of them dies, and that person says, I leave my share of the trust divided to the remaining 2 members. It just keeps passing on to you, right?
Yeah.
Okay.
Well,
And then what happens?
the trust is normally for those instances where it's like large amounts of owners, and they actually want to keep it as family property.
Okay.
So when it's just a house, unless it's like, a historic house, or like maybe a lot of people in Louisiana have hurricane houses out of state,
Right.
where it makes sense to own it as a group.
Got it.
For like a residential house, I don't know if that's the right way to do it, because yeah, it could just keep getting split like that.
Okay.
But if it's like, let's say if it's a rental property or something like that, then yeah. But it's that strategy is mostly for property where it makes sense to own it as a family.
Got it. Okay.
Yeah.
On a paper will that you handwrite out.
Yeah. Holographic will.
Photographic will. Would it be recommended to, at the time that you write it out and sign it, to get a picture of it on your phone that would be timestamped?
Yeah, it's always, one, you have to make sure you follow all the formalities. It's always useful to have a picture of it, but like, I think somebody asked a similar question earlier. That picture, that Xerox of the will is not the will. In Louisiana, the physical paper is the will. The
But
thing,
it would prove.
it to a
that
point,
it
yes,
was- That it had been done at that date.
at that date, yeah. Would it prove that the actual date on there would prove that it had been done at that date? But it would act as a form of proof. I will tell you, I do not recommend that people rely on an holographic handwritten will. I personally believe it is a stopgap measure. Let's say you can't get to the lawyer, you can't get to the notary, maybe the person's terminally ill. Yeah, holographic will, or if it's a person who is a very low income and they haven't found a lawyer who can work with them yet. Yes, holographic will. But I do think of it as a stopgap and I would not rely on it personally.
I have a question living in Louisiana,
Yeah.
and you talk about the original signed will. Where's the best place to store that? Is that a safe deposit?
I was just on the phone with some high-powered fancy attorneys in New York City, and they asked me that question. I'm gonna give you the same answer I gave them. I don't know. I struggle with it. Some people have lawyers that, okay, let's just start with this. There's one surefire thing you can do, but it's very expensive. You can file it with the property records. You can file your will in the property records. That's a very expensive thing to do. Not to mention, what's that? It's about as, I think in Orleans Parish, I haven't filed anything in a few months. I think it's like $375 to file something in Orleans Parish in the property records.
$375.
But the issue is, okay, maybe that's not that much to you. But the issue is if you want to update your will, that's another $375. Yeah. So, but as far as like what's the best place to store it, I can't really tell people where the best place to store it is. It depends on your circumstances. Some people have attorneys that they pay an extra fee where the attorney safeguards the will for them and notifies everybody. That's, like a instance, like you remember that movie Brewster's Millions, where the lawyer okay, that's my last pop culture reference that doesn't work. Another thing people do, there's the idea of the safety deposit box. There are issues with the safety deposit box. One of the obvious issues is if it's a disaster, you might not have your relatives might not have access to the safety deposit box. They might not even know that it exists. So in Katrina, that was an actual problem where people died and it was like their wills are in the safety deposit box, but the bank is closed. The bank or the bank's physically not there anymore. Yeah. So I can't recommend the safety deposit box just because I've seen it go sideways enough times. Yeah. But depending on your circumstance, maybe that is the correct thing. I do want some surefire things, not surefire, but some things you definitely have to do is notify your family that you have a will. And if you're comfortable letting them know what the will says, you don't have to give them a copy of it, but like letting them so it's not a surprise to people when it comes down. Yeah. If you disinherit anybody, they will challenge the will regardless of what they say. I think that's we covered a lot. We got any closing questions? Oh, let's see. Let's get to this Q&A. Okay, Janice Bucket. Our will was prepared by, so I think my understanding of it before was that the city was saying that it was not a valid will. Okay, so what you're saying is well, it depends on what you're trying to do, and that's kind of the impetus for this lesson was to let people know that there are certain things that if you don't go through with the succession, that certain government agencies, certain nonprofits, they're not going to be able to service you, or they're going to be unwilling to service you unless you have the succession, or there are other options now. There are things like the small succession, but specifically, let me actually put the number in the chat now for you guys.
So we did.
Okay. So with your specific issue, Ms. Bucket, definitely call that number and try and get in touch with Maureen at Southeast Louisiana Legal Services or anybody on their successions team. because really that's what we're doing. If you might happen to be low income or elderly, yeah, we have an incredible grant from the AARP to specifically help people in your seeming situation. Well, that's all the presentation I have for you guys. I can't believe I talked for that long. Thank you guys for coming.
All right. Thank you very much. Thank you, Jonathan, for everything. If you guys have any questions, feel free to reach out. Everyone should have gotten an email from me today if you registered. So feel free to reach out to me for questions. Thank you all so much for being here.
Thank you.
How'd you guys?